Good afternoon, everybody. My name is Chris Justice. I'm an employment lawyer with Samfiru, Tumarkin, and as always, I'm here to join you all, hopefully to answer as many questions as I can, all things related to employment law, of course. So any of you out there that have questions, maybe it's about a contract you're looking to have reviewed, or you've got some questions around that. Maybe you're going through something in the workplace, some sort of harassment situation, or maybe there's been changes to your employment that you don't agree with, or perhaps you've been let go or informed that you're being placed on a layoff. Again, whatever it is, definitely get your questions in here, and I'll do my best to answer as many live today as I can. As I also normally do, I like to start off before some of the questions come in with a topic or maybe some news of the day. This time around, I wanted to sort of quickly touch on terminations for cause. There's basically two ways that people can get let go or terminated. Number one would be on a without cause basis. So maybe the employer is stating that there's a restructuring going on, a reorganization going on, through no fault of your own normally. Or they just don't see you as the best fit and they decide to part ways with you. In these cases, without cause, typically you're going to be, of course, owed severance, and the question is going to be how much. But there's also another form of a termination, which is a for cause or a just cause termination. And that's basically where the company is saying that they're letting you go specifically for something you did or didn't do. So it's not a situation where, we're restructuring the company and we've had to cut some jobs and make things more efficient. It's more so putting the onus on you and saying you've done something or didn't do something that is very serious. Typically, when someone does allege just cause, when a company says they have cause to terminate, if they're doing it right, it should be something that is very serious, some serious form of misconduct that you've engaged in or not engaged in that's a form of misconduct that basically leads the employer to think that there's no possible repair. There's really no alternative now other than to let you go for just cause. And unfortunately, a lot of times companies terminate people for what they say is cause, again, something that they think is very serious, very egregious. But then when you actually look at the reasoning for why or the basis for their termination, you quickly find out that it's actually not that serious, certainly not serious enough to sort of rise to the level of a cause termination. And in those cases, maybe you did something wrong or you didn't do something you were supposed to, but it's so minor or it's relatively minor that even if it's true, it's not cause. So that's one reason why if you're faced with a cause termination, you shouldn't assume that the company has cause. You shouldn't take the company's side and believe that what they're doing is correct, because a lot of times, as I say, what a company thinks is cause is actually well below that. There's also other issues where a company may start writing somebody up. Somebody gets, maybe a warning, 2 warnings, 3 warnings. Maybe they're put on a performance improvement plan. A number of months pass, and the company is saying, well, we think we have cause, and this isn't just a minor thing. We've warned you about it multiple times. We've given you chances to correct your situation, and we've just run out of chances to give you, and therefore we're letting you go for cause. Now, in a case where a company sort of issues multiple warnings or a performance improvement plan before they decide to let you go, again, a lot of people think maybe that they've got enough against me that I might be dead to rights. I don't really stand a chance. Maybe there is cause. But even in those situations where they've documented this before, where they've given you warnings before, it still doesn't mean that there's necessarily cause. That might be one factor that the company can point to say, we've given this person multiple chances, which would be different than if they didn't, of course. But again, when you do some further analysis, you sort of look into the previous warnings that were given, or the PIP, or the performance improvement plan that was issued, again, you'll often find that either the warning letters aren't true, maybe they have made some things up, maybe they've taken some things out of context, maybe they, have heard you respond to these warnings and they just don't want to hear anything of it, and they think that just by virtue of papering their trail, putting things on record, that they have this cause case. But again, you look at things more deeply, you look at it sort of nitty gritty, and you find out, well, maybe this warning was bogus, or this warning, they weren't really considering this or that. So again, even in those situations, still relatively rare for a company to have cause. And of course, if they don't have cause, then you're looking at a without cause termination, and you're looking at your full severance in most cases. So you definitely want to get some legal advice, whether it's without cause before you sign off on any kind of a severance package. You want to get legal advice even if there is cause, or there were causes being alleged, because again, a lot of things can be sort of taken out of context, or the company might just be cherry picking certain things that it wants to focus on and then ignore other things. So again, cause is very hard to reach or to meet for companies. It's reserved for only the greatest, most egregious of offenders out there. People that might, lie time and time again, people that might be stealing from the company. There are certain things that a person can do that would go against the trust factor, and sort of attack the trust within the relationship between you and your employer. In some of those cases, companies may have more of a leg to stand on, but a lot of times you'll see companies just criticizing people for their performance, writing them up for their performance, and then letting them go for cause. That's very different than someone who may be lying a lot or stealing from the company or assaulting an employee, for example. I mean, again, you're sort of looking at the most egregious of situations when it comes to a company having any chance of succeeding in its cause case. But even somebody who's a poor performer, or even somebody who's been performing below par for a number of months or for a period of time, and even someone who's been warned about this many times, in most cases, even then, there's still not cause. So again, all the more reason to get your package or your termination letter checked out by a lawyer, get some legal advice before you just walk away, because, unbeknownst to yourself, you might be walking away from tens of thousands of dollars, if not more. And unfortunately, a lot of companies do this and they don't hear back from employees, and a lot of employees just sort of go on their merry way, maybe find another job. And so that's another reason why a lot of these companies sort of put forward these cause allegations, because they think that most people, or a lot of people, are not going to bother, criticizing that decision or getting a lawyer involved. So from their perspective, it might make business sense to let people go, in bad faith, perhaps, knowing that only a fraction of them will actually get legal advice. So all the more reason, if you're in that situation, just err on the side of caution, get some legal advice, at least before moving on and sort of, checking it off your list or off your mind. There's also other situations when it comes to cause where, for instance, somebody may not be performing well in their job, and the employer may say that they have cause because they've warned this person time and time again and there's been no improvement. But maybe there is an issue with the person's health, or a disability related matter that is affecting their ability to do their job, maybe reason why they can't do their job as well. And so sometimes companies can get into hot water when it comes to making these cause allegations, because there is in some cases an overlap between what they're saying the employee did wrong or didn't do and the employee's health status. And so a lot of times, if a company says, we're letting you go because, you're not performing up to par, up to snuff, but then there's medical evidence showing, well, here's why I can't perform as well as I did, or something along those lines, then not only would the company be in sort of hot water as far as having to pay you your severance because there wouldn't be cause, but also they would be opening a can of worms as far as there being potential human rights violations. So if I injure myself or injure my leg, for example, I'm not as mobile in the workplace, and then I get criticized because I'm working at a slower pace. If you sort of look at it in isolation, you might think, well, I'm working at a slower pace, maybe they have something against me. But then when you link it to a disability, for example, then the employer is basically infringing upon your human rights. They're arguably violating the human rights code, whether it's in Ontario or whether it's on a federal basis. And again, that's when you can get into some hot water from the employer side of things. So I think it's also all the more reason why employers need to make sure before I say I have cause, do I actually have cause? Have I done what I needed to? Have I canvassed all other alternatives? Have I tried everything before jumping to a termination for cause? And is there any sort of human rights related factor that might overlap with the reasoning for why we're letting this employee go? So again, whether you're on the employer side or the employee side, always beneficial to get some legal advice and just double check before you pull the trigger, especially if you're a company, because you can avoid yourself a lot of hassle, a lot of headaches by doing that, and then not having to face a future claim, lawsuit, maybe involving human rights related damages. But with that said, I'll get into some of the questions, and if I've got some time left over, I'll go back to talking a little bit more about cause sort of scenarios. So I've got a first question from ASD on YouTube who's asking what a summary judgment is. So a summary judgment is one way that you can essentially finalize or sort of come to a conclusion in a lawsuit. Normally you start a lawsuit, the idea is you're going to go to trial. So there might be witnesses, you might have to get up on the stand and testify. But a summary judgment is a bit more of a simplified procedure. It's another way of concluding a lawsuit. It's just not one that involves the full-blown trial as far as witnesses and evidence and testimony and people being on the stand and all this kind of stuff. Rather, it's more of a paper-focused trial. Summary judgment cases are usually reserved for cases where there isn't a lot of facts that are in dispute. So it might just be a question or a situation where, both the company and the employee agree on all the facts of the matter, and rather it's just a question of how the law interprets those facts. So, in that case, a summary judgment might be more beneficial because you don't have to go through all of those hoops that you would normally with a trial. You can get a trial or a summary judgment in some cases heard a lot sooner, a lot sort of quicker than maybe going through the process to get you to a trial, which could take several years. And all, again, you're looking at are the legal issues. We agree on A, B, C, D. Now, how does the law interpret that? What does the law say about those facts? So it's really just a matter of the lawyers arguing over the law, how the law applies to the facts that everyone agrees on. And as I say, a lot of this, if not all of it, can be done in writing and sort of cut down on costs. So summary judgment is definitely a useful tool. If you have a case that is more simplified, something that doesn't have any facts that are in dispute or that are being contested, maybe it's just a question of how much severance am I owed, and that's the only issue you're looking at, then that could very well be a case that is ripe or appropriate for a summary judgment. But it'll kind of depend on a case-by-case basis, and it's probably something that you should discuss with a lawyer, either before you start a lawsuit or along the way, and maybe if you've already started a lawsuit, just to kind of bring finality and a conclusion sooner. And as I say, again, saving on some costs. I've got another question in from Vic, who is saying that they were offered a job that was only listed work hours. So just the hours of the job. Then they asked about the pay. Turned out to be minimum wage, and the company, it looks like, was not willing to negotiate on the pay. So they're saying, it's minimum wage or nothing. Vic's saying that the company uses a US HR system, and said that they could start before a background check is cleared. And there's no official contract because it's at will. The whole situation seems like a major red flag, especially since I don't think at will employment is legal in Canada. So you're correct. There is something known as termination at will in the US. And sort of my understanding of it is that it allows employers to let somebody go sort of on the spot at will and not necessarily have to pay them anything or much of anything as far as severance. But that, as you pointed out, is not the law in Canada. Fortunately for those who are let go, there are in a lot of situations more options available to them. There's more rights as far as severance is concerned. So anytime someone is let go and they're working in Canada, even if it is for a US-based system, they're likely going to be owed severance. And as you say, there's nothing really like at will as there would be down south of the border. Now, you also mentioned that you could start working before a background check is cleared. So that sometimes can happen where you'll work for a company for a week or two, or maybe even longer, and then the background check gets cleared and you either continue working or the company says, maybe you didn't pass the background check, so they're letting you go. Now, if you've already, though, worked for the company for a week or two or three or four, and then they come to you a month or two or whatever later, and they say that the check didn't pass, we're going to let you go, then in all likelihood, you're still going to be owed your severance. You may not be looking at as much severance as you would if you were there for 5, 10, 15, 20 years. But there have been cases in Canada and in Ontario where people have been working for a company for just a few weeks and they go to trial and a judge has awarded them a few months. So it's not to say that if you've been there for a very short period of time, even if it is a week or two or three, that you're going to be owed nothing. You could get potentially a significant amount of money as long as you can, of course, show that you worked, you performed the duties of that particular role. Then you do have the option available to you, even if, like I say, a background check doesn't clear or there's no written contract. A lot of times employment starts maybe on the basis of a handshake or some verbal evidence, maybe a verbal back and forth between you and the employer, and they say, you're ready to go. This is your start date. Come to the office on this day. That's also good enough to create a contract between the employer and the employee. It doesn't have to be written down. And in fact, in most cases, if you don't have a contract in writing, it's probably better, because usually when you have something in writing, often it's going to be 5, 10, 15 pages long. And, it might, clarify how much money you're making and the job you're doing and your hours and vacation and all this kind of stuff, which is nice to have as far as, clarity and transparency. But then the other 90% of the contract in writing is going to have language or sort of sections in it that benefit the employer. And so in most cases, if an employee signs a contract, especially one that's multiple pages in length, a lot of times they may not realize this, they're signing something that potentially is going to limit their rights if they do ever get terminated, as an example. So that's all the more reason, if you are faced with a contract in writing, to get it reviewed by a lawyer. If you're not, then, as I say, in most cases, that's probably better, because then there isn't going to be anything in writing that limits your rights, limits your entitlement to severance, and at least give you more of a potential to get something on the higher end of what you would be looking at severance-wise versus just, say, the bare minimums that would be owed to you under legislation. But yeah, that at-will thing does come up a lot, and I think a lot of U.S. companies are obviously mistaken about it applying. They think that if the company's maybe based in the U.S., they can rely on U.S. law. But I know a lot of people who work in Ontario, maybe remotely, let's say even, or for an office of the U.S. companies that they might have in Ontario, and they only work in Ontario, even if it's a U.S. company, they're still going to be generally looking at the laws that apply in that province, wherever you work. So it could be Ontario, it could be British Columbia, it could be anywhere. But even if it's for a US-based company that has no office in Canada, the fact of you being there, working, again, maybe remotely from Canada, those are typically going to be the laws that apply. I've got another question in from Brennan, who's asking, if you have a commission structure in your contract, how much is an employer allowed to make changes to that before you have to sign off on those? So I guess the question is, did you sign off on the contract already, or is the contract only now being presented to you? Because if you've started with a company, if you started a job and you sign a contract and the contract says you get a commission of, say, 30% of your sales, and you start working on that basis, well, it would be natural for you to expect 30% of the sales that you make. So you'll want to see, first of all, did you sign a contract? Does it mention a commission structure? And what does it say about the commission structure? Does it just say you're going to get 30% of all sales made? Does it say that you need to complete steps A, B, C, D, E, F, G before you get the commission? So that would be one thing. If you've got something in a contract that you've signed talking about commissions, and let's say it says you get 30% of what you're paid, and then sometime after the company comes to you and says, well, now we're only going to pay you 10%, and you haven't signed anything about 10%, just 30, then that would, in many cases, if not all cases, constitute a significant change to your employment, to the terms of your employment with that company. And anytime a company makes significant changes to your contract that have already been put in place, you have the potential right to claim that that is a constructive dismissal, which is where there's been this big change made without your consent. So it goes to the question, did you consent to the change? Did you agree to it? Did you sign off on something saying commission rate would drop from 30 to 10% or not? Because if it's already established and then they make the change and try to force it on you, then you generally have an option of either saying, yes, I will accept that change. I'll move forward on that basis. And then, of course, you can't go back after the fact and try to get it back to where it was. Or you can potentially take the position that it's a significant change. You don't agree to it. You're not agreeable to signing off on anything that sort of confirms that change, where it has you consenting to that change. And then basically you'd be taking a stand here. Now, at that point, the ball is going to be in the employer's court. They may say, well, it's our way or the highway, in which case you've already said your piece. You've already drawn a line in the sand. And then you may potentially be able to then proceed with a constructive dismissal case and treat that change as though it's been a termination. Typically, the change, at least from a financial standpoint, has to reach at least 10 to 15% of your overall wages. So if your commissions per year are only $5,000 and the change is only going to drop it by $1,000 or $2,000, and otherwise you're making, let's say, $50,000 as a base wage, then the change may not be big enough. So you have to kind of look at, when it comes to the commission, what percentage of my overall pay does this commission make up, and how much of a drop am I experiencing by this change? And if it passes that sort of 10 to 15% threshold, then there's going to be a much more likely chance that there is a constructive dismissal. But I will say that before you kind of have a big back and forth with the company, I think this is a constructive dismissal, blah, 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 definitely better to give us a call first, just because we can look at your situation, sort of analyze, is it a big change? Is there a constructive dismissal here? Does this person have a leg to stand on? Because the last thing we would want is for you to go in and sort of state something as a matter of fact. It ends up not being a constructive dismissal or a big enough change, and now you're in jeopardy of having, be seen as quitting your job or creating some issue. And so we want to try to avoid that. But Brennan, when you're saying, as an employer allowed to make changes to a commission structure before you sign off, I just wasn't sure if you had signed off on anything beforehand. Sometimes you don't sign off on anything, like say you never signed off on anything saying anything about commission, but you were still matter-of-factly paid, $20,000 a year in commission, and now they're only trying to put it in writing, and you're looking at it and you're thinking, well, if I sign this, I've been getting $20,000 in commissions a year so far, but if I sign this, I'm probably only going to get, $5,000 or $2,000. Then yeah, that would certainly be a big change, even if there's just the one contract that's being put in front of you and nothing before that, because your terms of employment, maybe they wouldn't be in writing initially, but they'd be implied. So again, you don't always have to sign a contract for there to be terms of your employment, of course, and those terms can be created in a number of ways. They can be created through writing it down and having everyone sign off. They can be created just by happening. So if I don't sign any contract with my company, but they've been paying me $100,000 for 10 years straight, well, it's probably going to be a term of my employment to get $100,000. I expected in the 11th year to get $100,000. There shouldn't be a change. So they come to me and they say, okay, Chris, 10th year, 11th year with us, we want you to sign this contract. We're going to reduce your pay from 100 to 80. Well, no, that would be typically a constructive dismissal. So it'll depend on your situation, Brennan, but I definitely say give us a shout at the very least, just so we can talk to you about it, maybe just give you a sense of kind of what the best road to go down would be. And then, you'll be able to make a better informed or a well-informed decision. I've got another question in from Jenna on Facebook, who's saying that they were let go while they were recovering from surgery. They'd submitted the necessary medical documents, I guess, to support this leave or absence that they needed. But nonetheless, they were let go. Do they have any legal protection? So yeah, it would seem to me that you do. I mean, obviously, anytime someone is on a disability leave or recuperating from, say, a surgery, first of all, the idea would be that they'd eventually be coming back. So with a surgery, maybe you need a few months off, but then the company lets you go while you're recovering. The question I would ask is, well, did me getting the surgery have anything to do with my termination? If I had never had any surgery, if I didn't need it, if this never happened, would this company have still let me go? In a lot of cases, they wouldn't. It's but for the fact that you went on that leave that you were let go. And if you can show that or prove that, then you're connecting basically a disability or a protected leave to your termination, which would be a human rights violation. So then not only are you looking at your severance, like in a normal case when you get let go, but you're looking at, damages for bad faith, human rights damages. So very much not an advisable thing for people to be let go while on a leave, especially if the idea is the person is going to come back in the somewhat near future from the leave, and especially if they've been providing medical documents to support the leave. I think the company is just, playing with fire here. It's not to say that in literally every case, there can't be another reason for why they let someone go. But in most cases, if not all cases, it's going to look very, very bad on the company for having done that. The optics are going to look terrible. And I think in a lot of those cases, someone like you would have a lot of leverage to say, well, I believe it was due to my disability or being on a leave. It wouldn't have probably happened if I didn't go off on leave. And as I say, that's going to open up a can of worms for the employer and potentially entitle you, Jenna, to a substantial amount of compensation above and beyond just your regular severance. So definitely want to give us a shout there, because it looks like there's a fair bit that kind of hangs in the balance and that you could be going after the company for. But yeah, that's generally speaking a big no-no as far as what companies should be doing. I've got another question in from Emma, who's saying that they've reported unsafe working conditions and now they're being scheduled for few hours, and they're asking whether this is considered retaliation. Again, much like Jenna, the optics look very bad. It's like, oh, I'm reporting unsafe conditions. Before that, I'm averaging 40 hours a week. And then the week or two after I report these unsafe working conditions, now my hours have dropped from 20 to 30, or from 40 to 20 or 30. Again, the optics look very bad. Then in my mind, I'm thinking, well, had I not brought up these conditions, would I still be working greater hours? So that's one thing. The other thing is that if the concerns you have regarding unsafe working conditions are legitimate, and especially things that should be adhered to, and in terms of occupational health and safety or the employment standards legislation, and there's a clear violation on the company's part, and you're bringing that to light, well then, yeah, there are also protections against retaliation, against reprisal. The legislation in Ontario specifically sets this out. And the reason for that is because the government in Canada wants people to be able to come forward with these concerns without having to fear retaliation, reprisal. If it didn't exist, then people would just fear the worst and they would never report anything, and that wouldn't go towards the overall, arching picture, right? That we need to have safe working environments. It's a requirement under health and safety laws. So that's why there's anti-retaliation or anti-reprisal laws put in place. And just like Jenna, if you're let go, in response to raising a valid concern that they're either ignoring or now penalizing you for, they're going to be on the hook in that case for not only your severance, but further damages for the reprisal, for the retaliation, and bad faith. So again, big can of worms being opened up there. Not sure, obviously, on the specifics of your case, Emma. And again, all the more reason to give us a shout to kind of understand, what the conditions are, what's making it unsafe, Did the company reduce the hours you have because of something to do with you saying working these many hours for you is unsafe and they're trying to make some argument about accommodating you? I find that hard to believe, but again, just want to kind of canvas, where exactly they're coming from, what their argument is, what your argument is. But if it's for the things that I mentioned, then absolutely you want to get in touch with us, schedule a consultation so we can kind of walk you through what all your options are, because just like Jenna, there could be a lot of money to be had here. And, I think the last thing people want in general is for companies to walk away from this scot-free, not just for the person themselves, whether it's Emma, Jenna, whoever, but also for future, making sure that these things don't happen again, making sure that the workplace is made safe. But I do appreciate the question, Emma. Thanks very much. And that's actually going to do it for my time today, everyone. Thanks again for those that got their questions in. We do this all the time, every week. So for those that still have questions or maybe want to know about what's going on in the workplace, as you see down below there, Angus will be with you guys this Thursday, the 30th, to answer any further employment law questions. But for me, that's it. Do take care. Enjoy the rest of your Monday and have a great rest of your week. Thanks very much. Bye for now.